I cannot believe how ridiculous David Gingras, whatever, however you say his name, I can't believe how ridiculous his blog post is regarding the post-trial updates from the Clayton Eckerd and Laura Owens trial that just finished up last week. For those of you who do not know me, I am Boss Attorney Bri, and on this channel we cover celebrity lawsuits, and I recently got into this lawsuit regarding a former Bachelor contestant where he was sued by an alleged mother of his child, claiming that he was the father of her unborn twins that were technically still in her belly. And yes, Mr. Gringas, I am actually a real life attorney, and I am giving my opinion on this case as an experienced attorney in the family law courts of California. I understand that Arizona may be a little bit different, but paternity actions do tend to go pretty similar no matter what state you're actually in. I recently started covering this lawsuit where Laura Owens is suing Clayton Eckerd, a former Bachelor contestant, for being the father of her unborn twins. Y'all, I'm going to mess this guy's name throughout this recording, so please do not be in the comments trying to correct me in how to pronounce his name. I just don't know how to pronounce it, and I'm not going to spend a lot of time trying to figure it out. David Gingras is Laura Owens' attorney who has a blog that he apparently likes to ramble off on the decisions that the judge is making. Many Clayton Eckerd fans and Bachelor fans, and just people who are interested in the law like me, have started following this case because of the outrageous claims that have been made. Essentially, Laura Owens claims she was pregnant by Clayton Eckerd, but Clayton Eckerd said he never actually had sex with this girl, and she was unable to prove paternity during her trial. The judge just released the verdict of the trial, basically siding with Clayton and that Laura Owens was not able to prove paternity, and so basically Clayton Eckerd won the case. One thing that the judge did not rule in favor for Clayton for was the overturning of the order of protection that is against him protecting Laura, basically from Clayton saying mean things about her on the internet and abusing her, apparently. Unsurprisingly, Gringas was not very happy with the verdict of the judge and decided that he was going to get on his blog and make a post while he is allegedly on a cruise that is supposed to not have access to Wi-Fi. And instead of enjoying his cruise, he decided to write this blog post basically attacking the judge and the ruling that the judge made and talking about some case from 2008 that he apparently won, which who cares? But he decided to make this blog post basically saying that the judge is wrong and he's going to get it overturned on appeal. The blog is absolutely insane. And I just honestly think, as a lawyer to lawyer, if you're watching this, keep your mouth shut. Do your appeal and move in silence. Have you never heard of moving in silence? Anyways, let's go ahead and jump into what Mr. Gringas had to say about the judge's ruling and how he's going to somehow win this case by filing an appeal. And we're also going to jump into some of the comments because there were some pretty good comments on this post. Here is his post-trial update regarding the verdict that the judge put out. He starts off by saying, as far as I can tell, three types of people are reading this. One, members of the Clayton Eckerd personality cult. Personality cult? Okay. Two, normal folks who are interested in law, lawsuits, legal procedures, and maybe reality TV. And three, Judge Mata and her dad, allegedly, but hopefully not. Like, sir, why are you starting off so aggressively? He goes on to let us know that this post is only for folks in category 2. All others can stop reading now. These comments are not for you. Now, I would just like to point out that I am not Judge Mata or her dad. I am Boss Attorney Bri. I am not a member of the Clayton Eckerd personality cult. I don't know what that is. I just learned about this case maybe 3 weeks ago, and I am literally looking at the facts that were put into each party's pretrial brief. And I also watched the entire trial multiple times, and I listened to the evidence presented in the trial quite carefully. So I do think that I fall in category 2 of normal folks. I am literally just assessing the facts in a case that I cover quite commonly in my practice. So I think Gringas is giving me permission to keep reading this post. Of course, my guy is starting off quite salty, I must say. He goes on to say, now let's get into it. About 24 hours ago, the court issued a ruling that was 99% favorable to Clayton. The judge did not vacate the order of protection, so that's the only issue Clayton lost. Overall, and that one point aside, the post-trial decision gave Clayton pretty much every single thing he wanted and arguably more. Is this a victory for Clayton? Has justice been served? Will Laura end up in jail? Am I embarrassed? Wouldn't it kick my because we don't cuss on this channel, in court. Sorry. Am I embarrassed that Woodnick kicked my in court? Yeah, maybe. Fully understanding the answer to those questions begins a few important points. First, Clayton has won a battle, but the war is not even close to over. So this is letting us know that he is planning on appealing this nonsense. Like, why can we not just let this go? Second, I've been down this road many times in the past, and I can tell you it ain't over until it's over. Small victories, even huge ones, mean nothing if they are wrong and subject to reversal. If you were told you won the lottery and a few months later you were informed the ticket was fake and all the money was taken back, would you still feel like a winner? That is the question he has posed for us. Third, at the end of the day, the most important question that matters beyond all else is this: was the judge's decision correct? If the answer is no, Clayton's victory is a hollow and temporary one. And at this point, that question remains wide open. He goes on to ask, so how are Laura and I feeling? Where do we go from here? I'm going to share some thoughts on both the past and the future, but before we get into that, I have to remind everyone this is not my first rodeo. 100% of my legal practice is litigation, and I normally deal with cases a lot bigger and more complicated than Laura Owens versus Clayton Eckerd. That is not bragging or boasting. As Shakespeare said, what's past is prologue. If you want to understand the future, you need to consider the past and lessons learned from it. I'm going to spare y'all and just give you a summary about a case that he goes on to explain about his past victories from 2009. He thinks that it's a very similar situation to what happened in the Laura Owen versus Clayton Eckerd trial. He went on to explain that in 2009, he participated in a case where he felt like the judge hated him. Every ruling that the judge made was against Gringas and his client. The judge accused him of misstating the law. The case actually went to trial twice, where there was a hung jury for the first one, and then the jury ruled in favor of the plaintiff, who was not his client, at the end of the case. Gringas filed an appeal and took it up to the appellate court, who decided that the trial judge got it wrong and actually just reversed the judgment against his client. So congratulations to him, he won that appeal. But he's essentially saying that case is the same as this case, and I just do not agree with that. Okay, let's jump back into the actual blog post. Gringas says, all right, so what's the point of all of this? The answer should be obvious. Just because Clayton got a lone judge to agree with his claims does not mean that ruling will withstand appeal. And here's a serious side question for all you Woodnick worshipers. Okay. Has Greg ever handled an appeal? I can't find any evidence that he's ever argued even a single appeal, much less that he's ever prevailed in one. If you can point me to any prior appellate work he's done, I'd love to see it. This point is dumb for many reasons, and we're going to address that when we address some of the comments on the post. So Gringas thinks that there are a multitude of reasons why this should be overturned on appeal, or at least remanded for a new trial. For those of you who are not familiar with how appeals work, the appellate court does give the trial court a lot of discretion when deciding the facts of the case. I don't know the standard that Gringas is exactly going to be appealing under, but a lot of the standards of review on appeal revolve around whether the trial court abused their discretion in deciding the facts or considering certain evidence. The appellate court is virtually all writing. They can review the transcripts from the trial, they can review transcripts from deposition, they can review the evidence, they review the briefs that the attorneys are writing. They are not actually in trial and taking testimony from witnesses. So a lot of the body language and decisions of credibility that the courts come up with on trial court are usually upheld because the appellate court gives the trial court a lot of discretion. So it's going to be very interesting to see how Gringas is going to be able to convince the appellate court that the judge made mistakes on all of these factual and evidentiary issues when he has his client on the stand lying about certain things and admitting to lying about certain things. And they have no evidence that she was ever even actually pregnant, that she had a miscarriage, that there was DNA testing showing that Clayton was the father. I just don't see how this is going to be overturned on appeal, but let's see his argument. He says, now, as for this week's decision, here are my initial thoughts and comments. We need to hold a competition for the person who spots the most factual errors in this ruling. Let's not even include typos. I will give that to him. There were a lot of misstatements of fact. And I said that at the beginning of my Thursday live stream before I even seen this blog. The judge did have a couple of facts misstated in there, and there were some different typos and different spelling things. And we pointed out some of them during my actual live stream. So I will give that to Gringas. He got something right. So does anyone else find it ironic that the very first finding in the ruling is completely wrong? Laura Owens, petitioner, filed a pro per petition to establish paternity on May 20, 2023. Seriously? Does that mean the judge has committed perjury, fraud? Should the judge go immediately to prison? No. The judge simply misspoke and got the date wrong. In a case with so many moving parts, this is understandable. And contrary to what the insane clown JFC posse believes, people are allowed to make mistakes. This is not a crime, even in the Wild West state of Arizona. While I do agree with Gringas that this was just a mistake in typing out the date, because I think that's the day they actually hooked up, Gringas cannot compare the judge misstating the date to what his client did on the stand, which was just lie her patootie off, okay? He goes on to say, I personally can't even count the number of factual errors in this ruling. There are just so many, it's crazy. Like I said, there were some factual errors. I do agree with him on that. In terms of our ability to win on appeal, one of the finest aspects of this ruling is this nugget. Here, the court finds petitioner provided false testimony as to the viability of the pregnancy in all three cases addressed in the procedural history. Wow, such a powerful statement. And the evidence received at trial to support that finding is, wait for it, keep waiting, keep waiting. That's right, absolutely freaking nothing. Okay, like I said, I did watch the trial multiple times. There were questions regarding the pregnancies with the other people. And guess what? Keep waiting for it. Laura lied. Deandra asked her, those other people that you claimed you were married, or sorry, not married. Let me not throw that out there because that might be the next thing, okay? Those other men that you were allegedly pregnant by also didn't believe you. And that's not true. That's not, wait, let me get her voice on. Let me get her voice on. Okay.
No, that's not true. That's not true. Actually, Greg, he did believe it because he made me go get a test. Yeah, that's what he did. So he did believe that I was pregnant at some point.
Ma'am, the reason why he sent you to go get the test is because he didn't believe you. He did not believe you. So there was testimony. And for those of you who do not know, testimony is evidence. Gringas, as a trial litigation attorney, you should know that testimony is evidence. There was testimony that those men believe she lied about the pregnancies. And she admitted that majority of the men did not believe that she was actually pregnant by them. But then she lied when she testified that Greg believed that she was actually pregnant. It doesn't matter because allegedly she was never pregnant by them anyway. So whether they believed her or not is not really the crux of this argument, to tell you the truth. It's the fact that you're consistently trying to convince other men that you are pregnant by them whenever they try to break up with you, and then you go and get a restraining order on them when they want you to leave them alone. That is a problem. That was testimony that came in, and that was evidence that was considered by the court that is going to go to the DA to review whether Laura should be charged criminally for some of the things that she said on the stand and throughout the case. And that point only went to the issue of reporting her for the perjury. It does not mean that the whole entire decision is going to be overturned. They can overturn only parts of it if she wants to. And again, the court has discretion. The trial court has discretion. In order to get it overturned, they have to find that the trial court abused their discretion in making the decision that they made. The trial judge is the one sitting in the courtroom, reading body language, looking at everything. When you go up on appeal, all the appellate court is going to be able to review documents and arguments in writing. They don't get to go back and sit there and watch the trial and watch the depositions and watch all of these things. They get to read everything, and they're going to defer to the trial judge on their discretion of whether Laura was believable or not. And not only that, since they're going to be reading the transcripts, the appellate court is going to be able to look at those freaking transcripts and see that Laura changed her mind throughout the case. She changed her testimony constantly throughout the case, from direct to cross-examination. She gave two different stories. All of a sudden, she's in Los Angeles, and she never, ever said that during direct examination. Okay? Y'all, I'm getting a little bit heated. I'm not trying to be this hyped on a pre-recorded, Bri. Not on a pre-record. I tried to go over this before recording so that I'm not as hyped, and I'm still getting hyped because the more I read this nonsense, the more agitated I get. So let's get into the rest of his reasoning as to why it's going to be overturned on appeal. And funny enough, after I went absolutely crazy on that point, Gringas is still addressing this issue. So let's look at it. The single error virtually guarantees the ruling will not stand on appeal. And guess what that means? Yep, after the case is remanded for further proceedings, Judge Mata will be removed from the case. Not automatically. We'll get into that in a minute. That comes straight from Family Law Rule 6F, which provides for removal of the old judge after a case is remanded. Let's look at it. Like I said, not automatically. Okay, so Rule 6 specifically addresses what is necessary to remove a judge from your case. Mr. Gringas is saying that when the case is remanded, Mata will automatically be removed from the case. And that is not what 6F says. Let's go ahead and read it. In actions remanded from appellate court, the right to change of a judge is renewed and no event connected with the first trial constitutes waiver. If the appellate decision requires a new trial or contested hearing, and the party seeking to change a judge has not previously exercised the party's right to change a judge in the action. Now, at what point, please, let's read it again. Let's read it again, buddies, okay? Actions remanded from an appellate court. In actions remanded from an appellate court, the right to change of judge is renewed. Nowhere in there says that Mata will be removed. Nowhere. It's not automatic. You have to request it. Your right to change a judge is renewed. Do we want to go over what is required to change the judge? Let's look at the requirements to actually change the judge. What do? Either party has the right to change the judge, but in order to do it, you have to give notice that you would like to get the judge changed, okay? And there are time limits, which is 60 days before a contested hearing. You cannot ask to change the judge after the contested hearing is done. That does not renew your right to change the judge unless he is citing now. Now, I am not familiar with the entire family code from Arizona because I don't practice in Arizona. This is not my state of practice, okay? But unless there's another rule, which he does not cite any other rule, so I'm assuming this is the overturn the judge rule, and there's no other one. If there is another one, Gringas, please let me know. I don't know. But from the rule that you cited yourself, okay, the rule that you cited yourself, you cannot ask to remove the judge after the hearing because her daddy was there, and I don't like that her daddy was there because he had like telepathic communication with her while she was on the bench and had her rule the way she ruled. Sir, do you really believe this? In order to change the judge, you have to give notice 60 days in advance of the contested hearing. The contested hearing was on June 10th, okay? So if you wanted to contest the judge, he needed to do that back at the beginning of April or before that, okay? You cannot go through the contested matter and then email the judge a couple of days later and say, hey, judge, I heard that your dad was at the hearing and I think that's inappropriate. Why is it inappropriate? I don't know why the heck it's inappropriate. He is a member of the public. He's able to watch the case and he can have opinions on the case. We are going to get into why Gringas thinks that the dad being at the trial was inappropriate and what he heard, hearsay we're talking about, as justification to why he thinks that the judge should be taken off of the trial. Again, we are after the contested hearing. Your best chance, and I'm not giving you legal advice, Gringas, I'm not giving you legal advice, but your best chance of getting the judge taken off the case, whether she was done with her ruling or not, it doesn't matter. The contested hearing already happened. It does not require that her ruling be put out first. The contested hearing already happened. We are not in April. You cannot ask to change the judge at this point, okay? You go ahead and you ask to change the judge after because you're afraid, in my opinion, you're afraid of what the verdict might be. Inappropriate. Take it up on appeal. If the appellate court agrees with you, then you have 60 days again. Guess what? Gringas, you are going to get 60 more days to ask. Appellate court agrees with you. Guess what? Let's get into it. I want to read it with you. If your case is remanded back to the trial court, what happens? Your right to change the judge is renewed. So guess what? 60 days. 60 days. If you don't want Mata anymore, you might want to get the typing and writing your notice of a change of judge. That is my opinion. No, that's not my opinion. That's what the freaking rule says. Why are you misquoting the law on your blog? Why are you doing that? She's going to be automatically removed. No, she will not. It says the right to change judge is renewed, and no event connected with the first trial constitutes a waiver. So since you didn't ask to change a judge in April or before that, in this case, it's not a waiver anymore if the appellate court rules in your favor and decides to remand the case. So why am I giving him advice? Oh my gosh, he thought that the judge was going to automatically be removed, but she will not automatically be removed. And that's my point. I'm sorry, I've been yelling at the computer. Move on to his other reasoning. So again, misstating the facts in your blog, leaving out details from the trial, and also misstating the law. Absolute mess. Okay, let's go on. So we've already addressed Rule 6. So you incorrectly wrote that the judge is going to be removed. Judge Mata will be removed from the case. No, you will file to remove her from the case. Again, not giving you legal advice, and I hope you're not watching this because I don't want to help you out. Okay, let's go on. Judge Mata has only been a judge for a few years, and so far her track record is not good. Here's a recent case where a decision of hers was tossed out and remanded after she, wait for it, ignored a key procedural rule. That's a different case. Doesn't mean it happened in your case. There is other anecdotal evidence to suggest Judge Mata has a history of doing things which would normally result in a mistrial in any normal civil context. He goes on to give an example that Judge Mata used Google to basically do some research on the case, and she shouldn't be allowed to do that to decide facts of the case. He goes on to bring up, Greg Gillespie has been emailing me suggesting he's going to sue Laura. If you're reading this, Greg, allow me to remind you, bro, you already sued her. Very professional, bro. With Master Whitnick representing you, and you lost. You can't sue Laura for a claim that you already lost. We don't know what his claim is going to be. It could be for something else. So, of course, he can't sue again for the same issue. But if it's under a different theory, he could potentially sue. Just because it has the same facts does not mean that he already sued under all the theories that are possible. Okay, so we're finally going to get into Gringas' reasoning why the judge should not be on the case. We've already discussed Family Law Rule 6, and it just does not say what he says it says. I covered the whole rule on Thursday's stream. So if you want to go through all the requirements and how it doesn't apply here, I'll go ahead and link the timestamp to where I start talking about Rule 6 from last Thursday's stream. So here is why Gringas thinks that Mata should be removed from the case. About 12 hours before Judge Mata's ruling was issued, I sent an email to the court explaining that we believe there may be grounds to remove Judge Mata from the case for cause. Basically, there is a rule that allows a party to file a notice saying they have reason to believe a judge is either biased or unfair. In this instance, the concern was based on stories posted on social media that claimed Judge Mata's father attended the trial and afterwards he spoke to members of Clayton's cult. So hearsay. It's based on hearsay. Okay, let's go on. According to at least one person, the judge's father made statements implying that Judge Mata shared information about the case with him, including a suggestion that she was going to make an adverse ruling before the trial began. Again, that's going to be hearsay. Hearsay, hearsay, hearsay. Because you heard that somebody posted on Twitter and said that dad said that my daughter's going to roll against this. She told me she's going to roll against this. What judge would do that? Come on now. Come on now. Folks, and if that story is true, and at the moment we cannot confirm it either way, that would be one of the most outrageous acts of judicial misconduct imaginable. But because I am a reasonable person, are you? Okay. I did not believe it was fair to file a notice of change of judge, which would have gone to Judge Mata's boss for decision without first asking Judge Mata to explain whether the allegations were true. How would she know if it's true? How would she know what her daddy said? She's on the freaking bench. How would she know if it's true? Go ask her dad. Did you tell people? Huh? You can ask her, did you make up your mind about the ruling on this case prior to the trial starting? Like, what? Where is that going to get you? Where is that going to get you? Other option is to ask her dad, did you say these things? Or did your dad say these things? The lady's gonna say, I don't know. I was on the bench. Why? How am I supposed to know what my dad is talking about in the spillover room? So those are your two questions. You can ask, did your daddy say this? Or you can go ahead and ask, did you suggest that you were going to make an adverse ruling before the trial? What do you expect her to say? Yes, actually, I did do that. So yeah, you should overturn me on as a judge. You expect her to say that for real? Like, let's be for real here. Let's be really for real. You think she's gonna say that? Let's go on. Rather than just doing so, Judge Mata's clerk responded by saying the judge would prefer a motion rather than simply answering my questions privately. Was this an ex parte communication? That is a reasonable answer from a judge. Why are you emailing me, asking me about what my daddy is talking about in the spillover room? That is an appropriate answer from a judge. I don't know what you were expecting her to say. Based on that reply from the clerk, I began drafting the notice to remove Judge Mata, but as expected, she issued her decision literally hours before the notice could be completed. How do you know she wasn't already almost done? Just because you're on a cruise ship not enjoying your vacation doesn't mean she is. Okay. If I wanted and if I believed the facts and the law supported it, I could still file a notice asking Judge Mata's boss, the presiding judge, to remove her from the case. Because this phase of the case is basically 99% done, the only thing left is for Mata to determine the amount of Clayton's fees. I am not sure that's going to be necessary. As noted above, assuming the Court of Appeal reverses and remands any aspect of this week's ruling, we will automatically get a new judge. We already talked about this, Bri Hive. He will not automatically get a new judge. Gringas, I really hope you're not watching this because I don't want to help you. You will not automatically get a new judge. And that's all. Thus, I'm not sure there's a lot of value in raising the issue now. Attorney's fees, that's fine. I definitely understand that position. That's one thing I agree with you. No point of filing a notice to remove the judge when you're appealing it. And the trial has already happened. I'm so mad. It already happened. You can't ask the move to judge. You can't. Okay, whatever. Let's move on. Unless you have a different rule, I could be wrong. I don't practice in Arizona. Unless you have a different rule that says if they do something improper during trial, you can basically renew your ability to remove the judge for bias. I don't know where it would say that, but maybe there is a rule that magically says that. Let's go on. He says it was a lot of words, which he is right. He did use a lot of words. Okay, that's a lot of words, and maybe it's not the part most people case about. And I'm assuming he meant care about typos. Okay. So I will wrap it up with a couple comments on the two things I bet most people want to know. How is Laura feeling, and do I believe her story? As for point one, what can I say? Laura isn't happy. She's shocked. She honestly doesn't understand how the court got this so wrong. She didn't. The court did not get it wrong. She did not prove her case. Anyways, she feels betrayed by Judge Mata and by the court system as a whole. I keep reminding her of a couple things. First, you have to accept our courts are not perfect. It is a proven fact that innocent people are sometimes convicted and sent to death row. This is not one of those instances. It's not. That happened, and it's not even a rare thing. I guess the only explanation I can offer is that the courts are comprised of human beings, and humans are very, very imperfect creatures. Are you saying the judge? I know you're saying the judge got it wrong. Yep, you got it. You got it, Gringas. You got it. Yes, there are dirty, corrupt, self-serving folks all around us. There are also many good people. At the end of the day, while this is cold comfort to be sure, Laura needs to accept that this ruling does not define her. She says the judge got this 100% wrong, and she intends to continue fighting this as long as it takes. Why? Why is it not enough for you just to know that you were pregnant because you wasn't? But anyways, let's go on. As for point two, yes, after all this, I am still 100% on Laura's side. I believe she was pregnant. When do you believe she was pregnant? You believe she was pregnant with Clayton's baby? Let's be specific here. Let's be specific. What are you talking about? When do you believe she was pregnant? Don't be leaving details out, okay? And I believe the evidence shows she had a miscarriage that happened without her knowing it. No, the evidence did not show that. I'm telling you, I watched this trial, listened to it twice. The evidence did not show that she had a miscarriage. It didn't. All it showed was that she did not have HCG levels that was consistent with viable pregnancy, okay? And she said she peed on a stick. And then she also passed two fleshy things that she never went to the doctor to get it checked out. Had she gone to the doctor like a reasonable and credible person would do, then maybe we would have evidence that she had a miscarriage. But we don't. We have a lady who has said that she's been pregnant 3 or 4 times, and each time, no baby was produced from that pregnancy. in this particular case, she has no records proving that she was ever pregnant. HCG alone is not enough to say that lady was pregnant. And when we talk about the levels that came out during the test, they were too low at the phase of pregnancy she should have been in. So no, the evidence does not show that she had a miscarriage. Don't put that out there. In my opinion, I'm not giving you legal advice because I'm not trying to help you, sir. All it shows is that she had HCG. We don't know what the source of that was from. We don't. Okay. And also her own evidence from her own doctor said, I don't know, go to an emergency room. She decided not to do that. Okay, let's go on. But even if I give Clayton all benefit of the doubt and accept his view of what happened, I am still 1,000,000% certain the court's decision was still wrong. Laura tried to drop the case as soon as she reasonably could, regardless of why she made that decision. The fact remains Clayton could have simply let the case get dismissed and he would never have incurred a penny of fees. Why would he do that? You already dragged him through the media. If your client wasn't going to admit that she lied, okay, why would he drop the case? He needs a judgment showing that there is non-paternity. She did not show that he was the father of the child. If Clayton believes Laura lied about being pregnant, he could have simply sued her in normal civil court for defamation or whatever. No, he couldn't, because he does not have an admission that she lied. So basically what you're telling Clayton to do as not his attorney, not giving him legal advice, was to, okay, let me drop this paternity suit, file a defamation suit, and say she lied to me that she was pregnant. She lied that I was a deadbeat father. And how is he going to prove his case? She's not admitting that she lied. That is clear from the testimony that was given during the trial. She's not going to admit that she lied. That's just not a thing. That's not happening here. And he doesn't have a judgment showing non-paternity. Now Clayton has a judgment showing non-paternity. So if he wanted to file for defamation, he definitely could, because the court only awarded attorney's fees. He can then go and file a defamation case and ask for his lost money, because she went and told everybody under the sun, right? She told everybody under the sun that he was a deadbeat and he was losing contracts. Now he can sue for defamation. But just dropping the paternity case and then suing for defamation would have done him no good, unless she was going to agree to publicly come out or even privately come out and say that she lied. And she is not willing to do that. You're not willing to do that. You're not willing to do that. She's not willing to do that. So why would he drop the case? He needed a judgment. So don't say he could have just dropped the case. Your client could have never brought the case. How about that? Your client could have never went to the Sun and told them information. How about that? Your client could have never texted his mama, his cousin, his friends, and his coworkers. How about that? Talking about he could have just, no. Why? Why would I do a favor for her? She won't even admit that she lied. Let's go on. But he chose not to do this, presumably because convincing a jury of 12 neutral people to rule against Laura is a lot harder than convincing one judge with a father who apparently is a fan of one side. Who cares who her daddy likes? Bro, you are speculating. You're speculating because her daddy thinks that your client is a nutcase, potentially, allegedly is what you're claiming. Just because her dad thinks that doesn't mean that the judge thinks that. But I mean, after watching the trial, I don't see why the judge wouldn't think that. But it does not mean that she was influenced by her dad. Any reasonable person can look at that trial and say, did she just change her story? She really just changed her story on the stand. Think any reasonable person. I will be the first one to say, I came into this case about 3 weeks ago, knew nothing about it, read the facts, read your pretrial brief, read the other side's pretrial brief, and I watched the trial. And I'm a lawyer and I do paternity actions. I think any person watching that trial could find what the court found. She did not have evidence that he was the daddy. She did not have evidence that she was even ever pregnant. She didn't even have that evidence, other than her telling us that she peed on the stick and then she did a very, very low numbered HCG test in October, not even at the beginning of the pregnancy. And then she changed it. She changed the results. She admitted to changing the results. She admitted to lying to that. Why not admit to lying to the whole thing? Come on now. I agree with you to an extent that convincing the jury would be harder because he did not have a judgment and he did not have an admission that she was lying. Once he gets one of those two things, it's not going to be hard for him to convince the jury that he is entitled to money for the defamation. Okay? I don't think it's going to be hard now, but it would have been a very dumb move for him just to drop the case and then try to sue her for defamation. Come on, you're a trial and litigation attorney. You know this. Let's finish up this blog. So for now, no further comments from me about this. I'm on vacation with my family and I intend to enjoy the rest of the trip. I took a break from my holiday to share these comments, but that's it. Back to family time now. Moving forward, I will not be posting anything further about the case. So for the rest of the blog, he basically says that he's not going to be writing about this case anymore unless somebody brings it up and he feels like responding. He reserves the right. No one said you didn't have the right to respond. You're the one telling us that you're not going to respond to this, but whatever. He also accuses the judge of making up her mind 6 months ago on the case, which is, you know, a pretty strong accusation to make. He goes, until then, thanks for all the passionate interest in the case. Yeah, I'm passionate. I'm very passionate about this case and I just found out about it. I'm happy to answer individual questions via email, but not from JFC cult members. All others are welcome to ask whatever you like. Sir, are you freaking for real? I'm not a cult member. Are you freaking for real? Can you please tell me that? Okay, so I wanted to address one of the comments that was pretty interesting from a fellow lawyer, or at least someone that's claiming that they're a lawyer. So this is coming from Pam. I am a lawyer who has tried many cases. I'm a trial lawyer like Woodnick. When a case is appealed by either side, we hire an appellate lawyer. There are many trial lawyers that don't do appellate work, and that there are many lawyers that don't do trials and that specialize in appeals. That is absolutely true. The standard here was proven paternity by DNA evidence, and there wasn't any. Claps for Pam. Claps for Pam. Claps, claps, claps for Pam. Because I also am a family law attorney. If someone appeals something in my particular law office, we do not handle the appeals. They will need to hire an appellate attorney. Appellate work is very specialized, and trial attorneys do not have the time to learn both trials and appellate rules. So there are very many trial attorneys that do not do appeals. Pam is absolutely right. There's no requirement that he has to do an appeal in order to be a good trial attorney. Pam is also correct in that the standard was to prove paternity by DNA testing, and she didn't do that. There was no evidence of that. And like I said earlier, there was no evidence that she was ever even pregnant. Pam goes on to say, whatever you did in this other case you described has absolutely nothing to do with this case. Agreed. Claps for Pam. What does that have to do with anything? In 2009? In 2009, you want us to care about a case you won on appeal? And that's the only... And that's the only example you got? Come on, bro. Come on, bro. Since we're being unprofessional, to try and take down a sitting judge because you don't like her ruling is beyond anything I've seen in decades of practice. You have no evidence that her dad influenced her decision. Pam is cooking, okay? Cooking like the cooking spray, Pam, okay? You have no evidence that her dad influenced her decision. Her dad can have opinions. Her daddy's opinions ain't got nothing to do with her. And you're talking about a post on Twitter said that her daddy was there. Boy, come on now. Let's go on. Y'all got me acting wild on here. Let's see. What else Pam got to say? Because Pam is cooking. Pam is cooking. He probably sat near Clayton supporters because everyone there besides Laura mom was a Clayton supporter. Laura lied about Planned Parenthood and she altered medical records. She did. All she needs to do is produce a real ultrasound. How did she know she was having a twin boy and girl with no ultrasound? Impossible unless she was lying about that too. The other two men she victimized, wasn't there evidence about that in Woodnick's pretrial brief and exhibits? Although Clayton asked for that to be considered as part of the trial, the court, they don't have to do that. And it doesn't sound like she did that. For the most part, maybe for the procedural history part of things, but I don't think she did it for any of the other evidence in the trial. But as I said earlier, there was testimony directly from Laura about those other pregnancies and that those men also thought that she was lying. One of them actually believed me eventually, but he did decline it initially. Either way, that was to support a referral to the DA, not the award for attorney's fees. Pam's cooking. Pam is cooking. Please get Laura help and stop taking her money. She knows she altered records and lied. She knows the body can't absorb twin fetuses at 24 weeks when she testified under oath at the order of protection hearing that she was 100% pregnant. You know all this too. How could she be shocked? Please, I beg you to get her help. Gringas actually responded and said, you can't be a real lawyer because real lawyers wouldn't make those arguments. Pam eventually ends up asking for his email so that she can prove that she is a real lawyer. And she goes on to say that she has several certifications of being a trial attorney, and she's going to email Gringas directly so that he can see all of her accolades and maybe get some information out of him as to why he thinks that this case is valid for trying to appeal. Sir, your client just did not prove her case. This blog is absolutely ridiculous. I think it misstates a lot of things that happen in a trial. It fully misstates a law. Check out Family Law Rule 6F. I went and checked it out. It did not say what you said it said. And you want the appeals court to believe your client when she lied on the stand? Oh, that was just minor perjury. She admitted to lying on the stand. Telling Clayton that he should have just dropped this trial. Why? He needs his evidence to go forward with the defamation. So if y'all want my opinion on this blog, it's absolutely ridiculous. I think that Gringas should take this down and stop writing stuff on the internet. If he's going to file an appeal, he should just file that appeal in silence and stop with the media circus around this. File your appeal, let the appellate court decide it, and then see who's right. But just because you do not agree with the outcome of the trial and you don't necessarily agree with what facts that the judge found relevant, which the court has discretion to do. The judge has discretion to decide credibility. The judge has discretion to do all of these things. So even appealing it and saying, well, the judge was wrong because there was no evidence of this, and then Clayton's appellate side comes back and says, well, actually, this is what Laura actually testified regarding these things. It's up to the judge to decide whether she thought that those statements were valid or credible. And the court just found that they weren't valid or credible. The trial judge is the one that's on the bench. The trial judge is the one that is using the discretion of body language, using the discretion of watching Gringas give signals to his client. The trial judge is going to be in charge of all of that, and all the appellate court can do is review the paperwork. So they're going to defer to the trial judge for a lot of discretion and the facts that she considered to be valid. Just because she got some other things overturned, we don't know exactly what happened in those cases, so I wouldn't necessarily rely on that. You're basically trying to shame her and having a different case overturned to prove that your case is going to be overturned. But we won't know if Gringas is even successful on this appeal until it actually goes up on appeal. So stop writing about it, be about it, file the appeal, and let's get this case moving. So that's all I have to say about this blog. It's absolutely ridiculous. Let me know what y'all think about it in the comments. And if you missed my verdict live stream, make sure you go back and check it out because it had a lot of information in it as to what the court considered important in making this decision and the actual decision that the court came to, not this BS that Gringas has up on his website.